self-registered in class.
Oh.
Hi, who are you? And then you like.
The ones who are sitting in.
Yeah.
Yeah, other than the text itself, it's like, not the kind of stuff.
How many sugars?
2. Yeah, it's a real shit.
Yes.
I decided last year I was going to be retired. Yeah, I figured after 32 years it was time.
You did. Wow. And you know what?
I did go out and retired. I had the choice of doing devastating things away, which taught me I'm used to going to the office because I go crazy. So my wife said, "You make this up. See how it goes. So I think unfortunately, I hooked up with a lawyer who's on the first floor in my building. Did a quick sublet. One file, per month covers it. Yeah, that's like how can you do it? And then I go.
So which one do you want?
If you want it, you can follow it.
Oh, yes, I'll get it printed.
Yeah. The other one.
I have both down. I have this one.
I have.
And then one. Provide them as handouts. Okay.
And then I'll let them know if anybody who's not here, it's just that you get it off my website. Right.
I believe the girls gave you it.
Yeah.
Just for asking them.
You always know when the cops go away.
Hi, sorry. You've been. Oh, okay. Okay, perfect. Thank you, actually.
Thank you so much.
And then let me have him. And I'll go get the printouts, okay?
First one, we had a long time, had a lot of trouble going through the whole time. Morning.
Good morning, how are you doing?
Good. Good. I'm like,
I heard a rumor, yeah. The writing looks suspiciously familiar. Oh, yeah, it's mine. That makes sense. I'm so many years ago. 2. Yes.
was it? No, but it's not out there.
This is great classroom space.
You're great. When?
I've been doing, probably done about 12 or 15 of these different programs in the area. And this space. This is, for some places they'll use a boardroom. If you get up to the 20, 25, you're getting tight. Others are kiosks, the old style, where everybody has his little, when you're looking over somebody, looking over that way.
Everybody's doing this.
Yeah. And you pretty well have to stand, otherwise if you're seated and they're hidden by their kiosk, you can't make eye contact. It doesn't work. I'm not sure where I'm supposed to sit. I'm going to be sitting on.
I think you can do whatever you like.
Wherever I go, because they're taping cameras somewhere. Well, I'll block the screen. Is the market starting to get a little bit busier, or is it still sort of sluggish?
It's really spotty. Some things are crazy busy and some things just
It's not moving.
Yeah.
Every time government interferes in the private market, even if their intentions are good, I don't call them intentions. They never really know what the hell they're doing. And they screw it up and they make a bad situation worse. So that
So Jack, you're not retired. I thought you retired.
I did, yeah. I sold my law practice at the
I used
end of.
to send you a lot of deals.
Yeah,
Where's the other?
you know, with the
Nice to see
light,
you.
oh,
I
no,
know,
no,
I
here,
know.
yeah.
How are you doing?
Yeah, the light was sort of blinding me.
It's
I'm
okay.
doing okay. I decided at the end of 42 years, heavily, you know, real estate, commercial, corporate, that kind of stuff, that I was going to sell to some competitors who were 15 years younger than me. My next birthday is September. I'll be 70. So
God bless
figured
you.
I'd done it for,
Wow,
I've
you
done it
did
long
great.
enough. And I was just telling Celeste, I had the choice, sitting around the house doing nothing, driving my wife crazy. Her expression from her late mother is, "I married you for better or worse, but not for lunch."
For lunch, that's
Which
good.
I like that story. That's a good story. And I gotta have somewhere to go because I can't just turn the switch off like that. You know, I'm so used to whatever. So I
That's the best
sublet
thing
an
to do.
office to keep myself in the same building from another lawyer. The rent's cheap. My telephone is a joke. And one small file a month covers my fixed monthly expense, right? So I'm not taking chances. It's not as if you rent some big place saying, my God, you know, I'm gonna bounce my rent check this month. You have to be an idiot to do that. And so what I'm doing now is I'm marketing largely through telephone calls and through emails. And I'm getting a decent response relative to when you try to solicit. I'm finding out what it's like soliciting stuff because lawyers usually don't do that. And that's what you're used to. And it can be very frustrating where, you know, you put in 3 or 4 phone calls, you know the message has gotten through, you know the person's not away on holiday. When I get the call 4, if I don't get an answer back, I just scratch the name. I figure if they're interested, they call back. I reached one guy on the phone out of 10 calls who was a manager. And the managers were the ones doing it, not the brokers. Half the time the brokers are not around. And told them that I was interested in doing the larger piece, the one that's on screen. And he said, wow, like we could use that. I said, all right, let me just do a fast little bio thing so you know who the hell I am, because he didn't know me, younger guy. And I'll send you the attachment off my website, which is this thing, and get back to me. I set it up. He sounded interesting. So usually if you can get that far, they're going to say yes. You know, the question is you got to speak to somebody. So what I discovered about myself, I don't know about you guys, is the first part to marketing is make a phone call so there's a voice and a name and a phone number, and then if it sounds like there's a glimmer of interest, follow up immediately.
Well, you're a wealth of knowledge.
Yeah,
I know
so, and usually I click because of this stuff. I'll say, wow. Thanks.
Welcome to the last 35 years of my life.
Yeah, well, you know what, and for me, this is strange stuff because lawyers don't market quite that way. And once you build the practice, and I was at it for 42 years, it just comes. You don't have to sit there, you know, banging a stick on a pot. So I'm in unfamiliar territory doing marketing, for which I have no training. It's all just common sense and reaching out to people. So that's great. Okay.
Okay. No, it's okay, we're okay. And then this is, it's all Wi-Fi, so you can just scroll down.
Oh,
right?
yeah.
And then if you want to,
Okay.
you minimize that, the other one pops up right away.
Yeah.
Okay, all right, we're all set.
That didn't work. I'm technically challenged.
There you go, you're moving through it. So it's all wireless,
Yeah.
right?
Scroll down.
And then there you,
Circle finger.
so you just go down like this,
Oh, okay, I'll try.
right?
I'm not good.
I'm not either, but
If it were up to me,
this
I'd
one
still
I've
be
kind
all
of learned it now.
If it were up to me, I'd still use a typewriter.
A
You know,
typewriter.
At some
Well,
point, you gotta
you've gotta create
catch the
class,
bus and
so
get out of town.
that's
so-
a great, right? But if you need, just
Yeah.
have any of them text me, because half
Okay.
them have my number.
Okay. no
All right, have a good one.
All right. Okay, I guess we can get going. It's 11. There's some cards up here at the end if you want. You can come by and pick them up. I didn't know how many we were going to have in here, so I grabbed the whole pile. And I'm I'm going to start off today actually out of order. When I made contact initially with Celeste, the material that I sent to her was a short piece on arbitration without hearings. For those of you who are here in the classroom, do you have a physical paper copy of that? Are you looking at it?
No, we don't.
You don't? Okay. It's on the website, and it's, if I can figure out what to do with this little clicker thing, it's on there as well. But what we will do is they have that all available. You're only, let's see, 1, 2, 3, 4, 5, 6, 7, 8. I may have enough paper. I'm old fashioned, I love paper. Okay, if you want to just pass these around, there's probably enough for everybody to take here. If there are any more, you can pass them back. So at least you'll have the paper copy. The two texts are on my website, and my website is available on my card. For those who are here, my website is Zwicker, disputeresolutions.com. I'll pass some of these out as well. Pass back any extras. We're going to have a lot of extras. As I said, I didn't know how many people would be attending. Okay, let's start at the beginning, and I'm going to deal with a longer text. That's the one that is screened in front of you. It's entitled Early Resolution of Conflict in a Changing Real Estate Market. And it goes for, in terms of paper copies, it goes for 5 pages. So it's a little longer than I normally write, but it's a primer on how dispute resolution works when you're out of the courts. And what I've basically said, and you're probably better off, don't worry about reading along because you can get hold of this stuff. They have everything online. The most important thing to realize when people get into conflict is there's a bit of a reflex reaction where people who are in conflict, we're talking about real estate clients, could be landlords, could be tenants, if you do commercial, regardless of whether you're doing commercial leases, you could be doing commercial real estate or residential real estate. You're on for a buyer, you're on for a seller, maybe you're double ending a deal. The reflex action that most people have is, I got to get to my lawyer, I'm going to sue somebody. We're primed that way. You know, we live in North America. Our neighbor to the south is extremely litigious. We're not as bad, but we, for a variety of reasons I won't get into, we've moved in that direction. We're a more litigious society today, where we start reflexively thinking we have to sue somebody than we were 25 years ago. There are a variety of reasons for it that I won't get into. Often it's a self-destructive response, and people don't realize it because they're panicking and they don't know what the options are. So the purpose of the longer piece, the one entitled Early Resolution of Conflict in the Changing Real Estate Market, I wrote that in March. The actual writing date was March 5th, so a month ago, a little over a month ago. And I did it specifically geared toward people in real estate to take into account the fact that the market noticeably started changing when the last provincial government changed the land transfer tax rules to block non-resident investment. And that was sort of the beginning of the tipping point. We didn't feel it all that much. I didn't, because I did an awful lot of real estate still in 2017. Started feeling the change by September, by the fall of last year, 2018. And suddenly, just the volume of deals, I'm not talking about price, just the volume of deals started coming down. I felt it in my office because I continued my law practice, and I ended it after 42 years. It was retirement time at the end of December. So I noticed, just keeping my own volume records, just anecdotally on a piece of paper, you know, Smith sale to Jones, Brown purchase from McGillicuddy, I noticed the drop from September to December. It was a good year to retire, but that's not why I did it. What the paper deals with is it deals with effectively the convergence of the provincial changes, the federal changes, the increase in interest rates, the toughening up of appraisals and whatnot by banks that were giving money away like crazy for probably too many years, and the stress test. Combination of all of those things has created a mess in the market. So then what wound up happening, and I don't know how much of it is still out there, it's really hard to know. The digests that I saw, some of the newspaper stories that I saw, suggest that there may have been in the area, in the GTA area, somewhere around 1,000 deals had failed because people had bought high, hadn't closed. A lot of it was pre-construction stuff from years ago, and they sold low. They were forced to sell low, if in fact they sold at all. So that was sort of the genesis of this paper. And the pickup point was, what do you do if you get caught in a situation like this?
Okay.
Yeah, there's an extra copy of one of these that you might not have, which is this. Okay, if you want to just come up and you take the card as well. All right, and what I basically said in the very first page of the material is, and the heading for it is, why litigation may be the worst possible alternative. Here's a quick stat. Anybody who reads a newspaper or tunes into any of the news networks, CTV, Global, CBC News, will know that the time frame for civil lawsuits in the big cities in Canada, and if we're worried about Ontario now, we're not worried about the rest of Canada, is 5 to 7 years.
Wow.
If you have a client, and I don't want to sound like a comedian because that's one of my sidelines, but if you have a client who is an older client who gets caught up in this, let's say somebody who's 70, 72, or 75, there's a chance they won't survive to get to their trial date. That might be sick humor, but that's the reality. It's just so bad that the system is not producing a result. It's a little bit like a factory that makes widgets. And you've got more orders than you have people, and you have machines to make the widgets. So you get a backup. What happens? You can't fill your orders. Then you have customers squawking afterward. Our real estate system has really hit the same kind of thing. And it's the litigation aspects of the way real estate has taken place have caused this backup. We can't get anything done. We can, but it takes forever. So the real question is, what are the options so that people don't hit the panic button and they hit the I'll sue the guy button, because that usually is the recourse. The first one is essentially something you do all the time, and it's called negotiation. You're doing it. I mean, the nature of your business, you're constantly negotiating deals back and forth. For the purposes of the presentation, I don't care particularly whether you single-end a deal or you double-end. If you do double-end deals, you know, there's risk, especially if there's a conflict. If you have a vendor and a purchaser starting a fight, you're the monkey in the middle. You don't really want to be in that situation. But that's your choice whether you double-end, right? It's simpler just to act on one side, not the other. Sort of like lawyers, that you don't act two sides when there's a conflict. First option is essentially a negotiation option. Try to sit the parties down and see whether or not there's a solution that you can negotiate. One of the problems that I find, and I've done this now, and I'm professionally trained, apart from the law end of it, I went back about 19 years ago and I started what are called ADR courses, alternative dispute resolution courses. What do they deal with? They deal with negotiation and with mediation. They don't talk about arbitration, that's separate. I did a couple of those certificates, and then I did a master's degree because I liked the material so much. I'll tell you why in a minute. And then somewhat more recently, got certified as an arbitrator and as a chartered arbitrator. The negotiation part is something that the clients can do directly if they have the ability to have an intelligent, creative discussion. And as long as their emotions are not getting in the way, that's often the biggest problem, is they're yelling and screaming and they're not thinking. Okay, it's all emotion and very little, upstairs. If that doesn't work, people with my particular training can consult. We can coach. It's called coaching on how to negotiate something properly. And that's without actually using a third-party mediator. It's just trying to go through some of the basic techniques of negotiation. What are the techniques? They're interest-based. What are the parties' interests? How do you meet them? And how do you try to figure out where the common factors are? What do they share in common? So where they have common interests and they would like to sort of solve something, the more they share in common, the higher the probability that you're going to get a resolution of whatever the problem is. If they share nothing in common, then they're more likely to fight and continue fighting, right, with all of the nasty stuff that's involved in that. So what I've told you in this paper, and as I say, it's about 5 pages. It's definitely something that they have here, and you can access it either directly or off my website. What I've suggested in the paper is that if people can't negotiate, even with your help, they're just not listening, and they need some third party to almost act as a go-to source, a discipline source. ADR practice basically recommends mediation. What is mediation in a nutshell? It's a staged process where the mediator has to be somebody who's neutral, like myself. Not taking sides with anybody, preferably doesn't even know who these people are. So it wouldn't be a client of mine that I'm acting for because you can't do that. So we have to, as mediators, if we're appointed to mediate a dispute between, we'll assume a vendor and a purchaser of a piece of property, we have to have not had an interest in whatever's going on. Be neutral, be fair, be even-handed, and be impartial, like a judge in court. You can't have a preconceived view and then start flying around the edges and whatnot. So that very typically is the obligation of the mediator. What we do at the beginning is we listen a lot. The talking is later, but we listen at the beginning as we're listening for information. In a typical mediation, if parties just can't talk directly without a mediator, we try to find out what their facts are. What are the facts? What happened? How did it happen? When did it happen? Who did it happen to? What are the costs of whatever happened? They're the typical question words. It's amazing, and one of my side things that I've been doing for the last 5.5 years is I'm a small claims court judge up in Richmond, a little white building that Major Mac and it's amazing how many people come before the court, not with lawyers and not with paralegals, because we're all trained, we're all coming from the same mental space, but the public at large can't tell the story. They start at Z and then they go to B and then they go to S and they're over at Q and then they're at R and they're back at D, and it's enough to make you pull your hair out. So as judges, what we wind up doing, and I've done this for a long time as a lawyer as well, it's the same mindset. Say, stop for a minute, start at the beginning. Every story has a beginning, a middle, and an end. You don't go from back to front, you go from front to back. Just tell me what happened, right? And just try to reconstruct it in a logical order, A before B, B before C, C before D. Usually what happens in the process of listening to the storytelling, we'll be making notes of what they're telling us, and each side gets a chance to present. From those notes, we very quickly do a bit of an inventory and find out, are they agreeing on certain things? Are they agreeing on certain facts? What we're looking for is we're not looking to blame anybody. This is not a court. Unlike courts where somebody is right, somebody's wrong, somebody wins, somebody loses. This is not a winner-loser type. It's not binary. We're not giving judgments the way judges do in court. What we're looking for is to find out from the facts, what interest do they have in common? If as a result of listening to each side, and don't let it go too long, it might be half-hour presentation that each side makes. If as a result of listening to them, let's say the vendor says, look, I have 5 things that are important to me. They're called interests or needs. And the other fellow shares 4 of those 5, maybe his 5th one's a little different. The wheels are going to be going in my head right away saying, great, they agree on more than they disagree on. That gives me subject matter to be able to work with, because they're agreeing on a whole bunch of things. So once we figure out the extent to which they have agreements, then the creative part starts, and that's what's called brainstorming. It's creative options. You start looking at them, and if they haven't figured this out on their own, and obviously, I shouldn't say obviously, in many cases they haven't, because the problem is, A, they're not trained to think that way, and B, they're emotional. So their emotions are blocking off their reason. Right? They're thinking with their heart, not with their head. So what we then do is we go to what are called brainstorming options and saying, what if the vendor, you do 1, 2, and 3? And what if the purchaser responds doing 4, 5, and 6? Or what if one of those things doesn't work because there's a timing issue? Right? Give you an example. You have a deal that falls apart. The purchaser can't close because he got in this buy high, sell low jam. But he has other property. And he says, I really don't want to spend 5 to 7 years dragging in the court system and paying lawyers' fees, which can be tens and tens of thousands of dollars, and then it's called line up and take a number. It's awful what's going on, especially in the GTA. I'd rather solve this, and whatever it is, if I have to take a hit, I'd rather do it now. I want to get the pain over with. Why would I want to get the pain over with, especially if you know you owe some money to somebody, is you want the rest of your life to go smoothly, and you don't want a cloud hanging over your head. Litigation's like a cloud, it just never goes away. Or it does, but 5 to 7 years later. People don't want to live that way. So what a mediator could probably help people with is say, look, do you have other property or access to other funds that could be a settlement fund to see if we can settle out the plaintiff, the vendor whose deal fell apart, because the
buyer couldn't close it. And is that money available now? Is it available later? You have to ask fact-based questions. I had one situation like that where the purchaser couldn't close, and legally he was responsible. Morally, he wasn't a bad guy. He got jammed up in a system that changed on him, 2017, 2018. But he had access to funds, and he had access to a possible mortgage on a clear property out in the country. And I said, if you're willing and if you're able to get the mortgage from the bank, why don't we try to do a mediated solution where for a certain amount of money, you agree that you're going to apply for a mortgage, hopefully get the mortgage, figure out what the timing is for all of that, because you can't, talk about it on a Monday and get it done on a Tuesday. Everything takes time. See if the seller rather will buy into that, and frame it in a way where you can get everything done within a time frame. This particular one was interesting because although the client who was in the bad guy position, the default position, was willing, he had an ability problem. He had a covenant in his mortgage on another property where there's a lot of equity, where he couldn't do any refinancing without the consent of the lender until a certain point. I said, all right, fine. And he was bright, he understood. I said, all right. I said, could you go to the lender? Obviously not now, we're talking, but could you go to the lender and see if they'll give you permission anyway? Because it's a written consent situation. And if the lender, worst case scenario, says no, you gotta wait until the agreement opens up. So he had about 6 months to wait to be able to open this up and go back to the bank and legitimately put on a second mortgage. I said, why don't you go to them? If they're sort of tough on opening this up for you now, and it opens up later, maybe the seller whose deal you defaulted on will play ball with you. He'll go ahead and he'll play ball with you and say, okay, fine, you know what? It's now January. I can afford, as long as I know everybody signs off on a deal, to wait to June. Better than waiting 5 to 7 years. We actually mediated a solution. And then what the mediator's job was is once we figured out how to put the pieces together, including the timing and what everybody was agreeing to do, the normal practice is we write up a memorandum. It can be handwritten, it can be computer generated, it doesn't matter. How fancy it is makes no difference. What you're doing is in point form, paragraph 1. We're basically doing a memorandum of agreement saying the seller will do this, the buyer will do that. If the buyer needs the seller's cooperation for something, we write out what his obligations are. I will do this, I will do that, and when I will do it, and how I will do it. And by doing that, we actually solve the problem. So what wound up happening at the end of the day is the seller took a calculation or did a calculation of what his legal expenses would have been to spend 5 to 7 years waiting for a court system that is just really backed up and dysfunctional. And if he was able to sort of get a resolution in the course of a day, that's a lot cheaper than spending tens of thousands of dollars blowing money on lawyers' fees. What do? You offer a discount, because that money would have been gone anyway if it was in a lawyer's pocket. So we were able to get him to agree to a lower dollar figure, a lower settlement figure. It's essentially what happened. That made it easier for the buyer to do his refinancing. So by playing a little bit at both ends where everybody gives in something, meaning compromise, the key word is compromise. Nobody gets 100% because there's no compromise if you do that. We were able in the space of probably about a half a day to get this thing settled without a lawsuit. Question, good.
When you create a creative solution like that, how do you counter the argument that says, especially if the conflict is really clear, like you
didn't close and you're liable.
Yeah,
it's a no-brainer.
Why would the seller not say, listen, I understand taking a discount to get it done quickly, but I think I'm clearly going to win in 7 years, and the judge is going to award me my costs.
Yeah.
Is he not? So why am I discounting for the lawyer's fees when if I tough it out long enough, I'll get all of that?
That's an excellent question. I'll give you an answer, which as a deputy judge, I'm delighted that this happened. At the end of 2018, there was at that point, a 3-year-old lawsuit called Canfield, just like it sounds, Canfield, versus Rockville, Ontario Speedway. And that's not in this material, I just became aware of it. What happened in that case was Canfield went to a car race out in Brockville. Something happened, some part flew off some car and he got injured. He sued the Speedway for negligence, negligent design, whatever, negligent security. The plaintiff's lawyer reached out to the insurance company, because this was an insured case. So there's always insurance in the background of these cases, and said, look, why don't we mediate this? In our view, the liability is clear. We're going to win. It's a question of how long it takes. And Brockville's not Toronto. You get to court faster, but still not so fast. Why don't we try to mediate what I'm talking about and see if we can come up with a package and get rid of this chestnut? The insurance company was a bit snooty, and they thought too much of themselves. They said, absolutely not. We'll go to trial. Rather than mediating, and the mediating could have been a year before the trial, 2 years before the trial, I think the case has been in the system within 3 years. So that's better than Toronto 5-7. Rather than doing that, they toughed it out. They went to trial. Canfield, who was the injured victim, won, and the judge dumped all over the defendant, meaning the insurance company. The insurance company picks the lawyer. So it's not the Speedway that doesn't go. It's always the insurance company. And what the judge wound up saying was very interesting. Two things. Because of the way our nutty system operates for judicial mediation in Ontario, the only areas where you were supposed to mediate cases within a lawsuit is Ottawa, Toronto, and Windsor. It's called judicial mediation. It's not the judge mediating. You hire somebody like me to do the mediation, but
it's mandatory.
But it's mandatory. But what this all goes back to sort of the early or the mid Harris days, where mediation comes in Ottawa, Toronto, and in 2002, Windsor, Ontario. And it's compulsory unless there's some bloody good reason why a judge gives an exemption. You have to get a court order to knock out the mediation. It's called an exemption. Okay. The rest of the provinces never had this. Those of us in the field, like myself, were hoping the whole province would roll this out. It didn't happen. Right? I don't know why, it just didn't happen. We're no better off now in 2019 than we were in 1999. Go figure. What does this judge do? He looks at a rule, and it's very funny. Very often, some of the rules at the very beginning of our rules of civil procedure, even as lawyers, we forget about it. We're so busy dealing with the niggly-piggly details that sometimes the broad brush stuff that is early numbers, like the number 1, is as low as you can get, we totally forget about it. What does this judge do? He looks back. He gets a glimmer all of a sudden. It doesn't happen often. He says, there's a rule 1.04. I mean, that's the beginning. Our rules go right up into the, the 75, 78, 80, and textbooks are 2 and 3 inches thick. So he looks up rule 1.04, and what does it say? It says that in any lawsuit, a judge's responsibility is to try to drive the litigation and encourage people to get to a just, efficient, and expeditious resolution of the issues, right? In the least costly manner possible. It doesn't talk about mediation. It basically is an empowering statute or an empowering regulation that says that in the back of a judge's mind, that's what people should be doing. If they're not doing it, the judge can make an order. What does he do at trial? He dumps all over the insurance company, and he says this: I couldn't have forced you to mediate a Brockville case because it's only Ottawa, Toronto, and Windsor where you've got compulsory or mandatory mediation. He said, but you had the opportunity to do this. You could have brought this one home a couple of years ago and avoided the expense and the aggravation for everybody. You didn't do it. You were stubborn. You actually called them stubborn in those reasons. You said, you're going to pay for it. So not only did the plaintiff win, not only did the plaintiff get whatever costs he normally would have in order to reimburse for his lawyer's expenses, but all the wasted lawyer's expenses that could have been saved through a mediation were almost like a penalty. So there was an add-on at the end. That's a great case. It's not a good case for litigators, but it's a great case if you're looking at it from a judge's point of view. Because what they're saying is, we're not going to put up with the stubborn nonsense anymore, where somebody knows that one side knows they have a good case, the other one is blowing them off. Right? And as a result of that, they're keeping something in the system longer than it has to be, which defeats the business of just, expeditious, and costly. One of the principles in judging that lawyers forget about, and I've been a lawyer, I still am, although I sold my practice last year. One of the things we sometimes forget about is, if you're going to get into a lawsuit, are you gonna spend $40,000 or $50,000, which is not hard these days, on a $20,000 case? This case wasn't 20 grand, but are you gonna blow your brains out trying to get into a lawsuit where it's just not worth it? So the lawyers word that we use is proportionality. There's got to be some ratio, some proportionality between what you're spending and what the damn case is worth in the first place. And if it's not there, the judges are going to be very, very angry. I know when I'm judging in small claims court, I'm constantly looking at the economics of what people are doing. Don't bring me a case for 17,000 in small claims and tell me that you'll probably spend $34,000 in legal costs, or they're going to get a dirty look. Because it doesn't make sense. If you have any business sense, you know it doesn't make any sense. So the very simple answer to your question is, especially with this case that now invokes Rule 1.04 and our lawyers' rules of procedure, this judge in effect was saying, I couldn't have forced you to mediate because you're not in Toronto, Ottawa, or Windsor, but because you didn't take the opportunity when it was extended to you, I'm going to penalize you now. When I saw that, my eyes lit up. This case was just released a little while ago. Good. Because what it is, it's going to discipline people into not being stupid and stubborn, the two S's that are really fake anymore.
So when the judge looked at that situation and said, basically, he said, you should have mediated.
That's right. Couldn't force you to do it, but now you're going to pay for not doing it.
Right. If a judge is looking at that sort of thing, they can't look at any of the details that might have been on offer in a mediation, because that has to always be set aside.
That's without prejudice.
Right.
Like the whole content of mediation is without prejudice. It's like you're bargaining back and forth. You don't discuss it, but the fact that the offer to go to mediation was part of the court record, the judge knew that. He also knew when the offer was made. The plaintiff offered to mediate, and probably, look, if you mediate, you're compromising, which means that you knock something off your claim. You know when you're doing buys and sells, that the vendor wants X, and unless the market's so nutty, it's selling over asking. But in a normal market, which we haven't had in years, maybe now we have a normal market, I don't know. But in a normal market, there's negotiation back and forth. And whatever the selling price is, if it's a more normal balanced market, is not going to be the asking price. Right? In a crazy market, you add on $100,000 and there's no value in the banks, like a bunch of idiots with financing this stuff until it all falls apart, right? Calendar 17 and 18. So long story short, the use of mediation is something, to get back to your question, where there is a risk to not doing it if it looks like it's just stupid and stubborn. And with this case, it's not the only case that went this way, but it was the first one where the judge actually said, I'm going to use a rule to penalize you for not mediating, even though I couldn't have forced you to mediate because we're not in Ottawa, Toronto, or Windsor. It's a great case. As soon as I read about it recently, I said, wow, this gives some tools to a judge to strike back and knock off some of the nonsense that lawyers are involved. And I know, not that I ever did this because I've been very settlement oriented, but there are a lot of lawyers who fight over 3 cents. And the problem is, who gets to pay for it? Clients do.
I have a question for you, Jack. In a process of litigation, let's say it is in that process right now, how do you come in? Like, how do we recommend you to a client and say?
What would happen is, let's say people are already litigating. And this Canfield case is a good example. They're already in litigation because their first instinct to sue the SOB who caused me a problem, and they're angry and they want to blame, the whole conflict cycle. If they were in touch with you, or if you're in touch with them because you're a client, you're just trying to keep tabs on what's going on, you could say, look, I know the name of a very strong mediator, right, who also is a judge, claims court level, who's trained in all of this stuff. There may be some other way of trying to put a deal together, put packages, and get rid of it, and don't drag it out for 5 to 7 years, especially if you're in the GTA. Like Toronto is a mess. Newmarket, which services the York region area, is not as bad as Toronto, but it's not great. The court in Oshawa, which services Durham, is better. Brampton's pretty jammed up also. There's a lot of judge shortages in Brampton. In Brampton, Mississauga grew like a mushroom in the last 3 years. So Brampton's not doing it. Some of the judges out there are complaining that they're overworked and understaffed, and that there are not enough judges in courts and the whole infrastructure. There's a horrible problem with that. So There's another little answer, I think, to your question. It's a great question. Is you have to look at your opportunity costs as well. Let's say that, and I've been doing some writing for magazines recently. I've had, because of the shift in my career, I've had a lot of quiet time. And I did some journalism years ago, which allowed me to do the writing style that you see in front of you. Mag style, it's not lawyer style. So I've landed about 10 publications in the space of 2 months. I've been writing like crazy, and pretty well everything has been accepted for national publication in different magazines. One of the things I've written on is if you get into a commercial real estate dispute, or any kind of commercial dispute, but real estate, you have to look at what the opportunity costs are of litigation.
What could you have done with that money in the 4
Well,
years?
not only
you were
that, but for example, I'm going to just change the paradigm because this makes it even more poignant in a way. Let's say you got two corporations that are involved in a real estate transaction, and that's their narrow focus. But let's say one of them buys product from the other. In the meantime, they're involved in some deal that goes screwy, and everybody lawyers up. But in the normal course, they're buying and selling from one another. And maybe whatever the thing is, let's say they make little switcheroos like this, right? Let's say in the course of a year that the value of the deals they could have had are basically out the window because they're not dealing, because they're in litigation with one another. It's almost like a business job. I can't deal with the guy because we're in court. We can't talk to him. We can't deal with him, whatever. What are they losing? By not settling a case that maybe there is a settlement on some terms. It's not going to be perfect. Nothing's perfect. Life isn't perfect. If it was, we wouldn't have these problems in the first place. But if they were able to sort of get this chestnut, this real estate chestnut out of the way, they could resume their normal buying and selling relationship and not forego whatever profit they would have made on those deals. So when I'm dealing with business people, I said, you better, like penny wise and pound foolish. You can go like hell on your real estate lawsuit, but could you be giving something else up that you don't have to? And then later you say, my God, why did I have to do this? I really stepped into poop doing this. Right? And a lot of people step into poop, and the only time they recognize it is years later when they sort of have a chance to calm down, they look at it and say, my God, why did I ever do this? It made no sense. So part of what a good mediator can do, to answer your question, is to sort of impart, depending on what the knowledge and background of the client is, a business purpose test, saying, have you really thought about what you're doing? What about this? What about that? The best mediators ask a lot of questions. And if you think about it, it's very interesting, the tie between law and mediation and also writing, journalism. Everybody here watched W5, or did somebody watch W5 on CTV? You're familiar with it. W5 is, CTV has a program called W5. It's basically an investigative program on the weekend. The CBC equivalent is the Fitness State. Right? They're both great programs. One's on CBC, the other is CTV. When I'm in court and I'm judging, I sometimes ask people who can't tell the story, I said, do you know what W5 is on CTV? Most people, 50% say, yeah, I watch it on TV. I said, do you know what the W stands for? Almost nobody knows what it means. As I said, I'm going to be 70 in September. Maybe we were schooled differently back then, but we knew in grade 2 that the W5, there was no W5 programs. Who, what, where, when, and why. All right, and then the other questions are either how, which is H, or did, with a D. There's nothing you can think of that's a question. It can't start off with one of the W5s, how or did. And one of the best things a mediator can do is just ask questions. Like, how would you do this? If you were to do it, when would you have to do it? Whose approval do you need? That's another question. Whose approval do you need? That would be W6, right? But for those, it's still good. So you're still asking questions that are driven toward trying to package something and make a deal that meets as many interests as possible and get rid of this thing, not have them bang themselves over the head. So I'm trying to partly answer the remainder of your question and also yours.
I think what you do is amazing.
Yeah.
Compared to what I know the cost of getting into this class,
I mean,
it costs thousands and people go bankrupt.
Well, you can. I mean, I don't want to, again, I didn't want to do sick humor and I did it already. So now that I've done it, I'll do it a second time. If I have elderly clients who are talking about suing, like people in their mid-70s, I said, I don't want to be gory or anything, but how do you know you're going to be around when this happens? Or even if you are, early onset Alzheimer's, you don't know what you're doing. what if we start something now, and by the time we have to get to trial, if you're even alive, your mind's not working properly, and you can't remember the facts. Judges have to have witnesses in a witness box, usually to the judge's left, saying, here's what happened to me, here's what went on, here are my losses. What if the person can't remember anything? What do we do? So, you know what, you're better off if you get rid of it earlier. You take a little bit of a haircut, you get rid of it earlier. You can finish it. Okay, that's essentially a fast primer, and it's in the material, which is on screen. And I'm still having trouble with this little wazoo thing over here. So there are copies available. Obviously, I emailed that off my site just so that she has it on.
I think we have it here.
Yeah, and
It's gonna-
okay, that's great. Read it at your own leisure. But what I've done with it is I've gone from litigation is the worst alternative. Largely, it's not only the costs, it's the delays, driving everybody crazy. To if people can sit, be rational, and stop blaming everybody, right? Think with their head and not with their heart. Negotiation, in which case they may not need us. If they need a third person, a neutral, to sort of corral them, bring them in. One of the suggestions that I make to people is if you think of conflict as a circle, right? You've got the center of the circle, you get a protractor, you draw a circle. When people are in conflict, they're on opposite ends of the circle. And if you look at the center of the circle, and the diameter runs right through, you get twice the radius as the diameter. What the mediator is trying to do is get them to leave their positions on the outer edge of the circle, follow the diameter, get closer to the center where the compass goes. That's what we're trying to do. Settlement can be to the left of center, it can be to the right of center, right? But that's what the game is to get them to move closer, not to have them out in the wings.
So one party comes to you, let's say the purchaser comes to you, how do you communicate that with the two lawyers?
Well,
The
okay.
vendor and the
Okay,
purchaser?
well, yeah, what would happen is, we're gonna get a call from somebody, and it doesn't matter who it is and what their situation is. If we get a call from somebody, one of the things I would do is say, look, have you discussed this with the other party? Because you both have to check in. If they both are willing to use the same mediator, because you can't have them fighting with a mediator. But, having said that, I'll tell you the exception in a minute, because you can have co-mediators. But normally it's one mediator. So if party A talks to party B and they say, yes, Zwicker, we want you to mediate this, we have standard forms of mediation agreements, 2-3 pages. Basically, this is Zwicker, you're going to be the mediator, or whoever it happens to be. And we don't have to say what the issue is. The fee structure is laid out. Any expenses, if we have to rent a facility because we don't have the office space for it, we have to find a facility somewhere where we have enough room space for people to move back and forth. That's on their hand as well. At the end of the day, it tells them what our duty is to be equal and fair and even-handed and impartial and all that stuff. In my mediation agreements, because I am a lawyer, non-lawyers can't do this, one of the things I write into the agreement is during the course of the mediation, if I think it's a situation that is so one-sided, so obvious, to use the example that we talked about before, I'm going to give an opinion to these people saying, I think Mr. A, you're much more likely to win, and Mr. B, you're much more likely to lose. And here's why. And that's called evaluative mediation. Right? Non-lawyers can't do that because they can't give an opinion. People who come to mediation with a law background, on the judge part of it, we're going to know very quickly whether one side is sort of skating on thick ice and the other side is skating on thin ice. It's not hard to do. Sometimes that encourages people to settle more quickly. Like the one who has the weaker side may not know until they're told you got the weak side. Here's what judges do, 1, 2, 3, 4. Sometimes I said, do you want to think about it? That's great. You give them a little, time out. They come back and they'll say, okay, you know what? I'm willing to modify whatever my last bargaining position was based on what you just told me my risks are. You never know where this is going to come out until you play it. But the mediator's job is to be fair, neutral, and be open with everybody and put the cards on the table.
A non-lawyer can communicate something similar by saying, listen, like, if you go to litigation, it's a crapshoot.
It is, yeah. You don't know if they're going to win.
If the judge woke up on the wrong side of the bed this morning, or his wife gave him a hard time on the way out the door, you might pay for that.
Yeah, you're right. One of the things I've learned because of the judging over the last exactly 5.5 years, and I was appointed in 2013, is I don't let my moods get to me. Like if I know that I'm in a little bit of an off mood, I'm very disciplined, so I will not take that out on somebody else. I just won't. And I'll know if I'm feeling a little off. Because you're scheduled for a certain day, you gotta do your job. But we bring to, and this is true of everybody, judges are lawyers, lawyers are people. We forget that sometimes. And whatever we bring to whatever it is that we do is a reflection of who we are. You've got some lawyers, and I met some of them, they'll fight over everything. I mean, they're just very argumentative and litigious people. And some of them that you meet, you would say privately, I would never be a friend to somebody like that. You can't talk to them. It's almost like you get a Donald Trump type of reaction. That kind of person. Stay away from them. You'll get other people that are very easy to talk to. They're very rational. They're reasonable. They're polite. It's a pleasure. And you make friends very quickly. I'm involved in a piece of litigation now, which is not from my client's point of view, on the other side's point of view. It's just stupid. It's real estate that's involved. We're about to sue for about $50,000 of losses. The client, the other guy, the opposite side, is what I call two S's, stupid and stubborn. One's bad enough, the two together are fake. But his lawyer is a really nice, reasonable guy. And we get along. We knew of each other, we never dealt. We met in court. I had a court motion to get rid of a construction lien that was falsely placed on my client's property. Buggered up the deal. She had to get the deal closed and and they consented to it. The lawyer was a pleasure to deal with. I know that if we try to talk settlement, just wait.
No, sorry, I'm just.
Yeah. If we try to talk settlement, I've got somebody I can talk to. The problem that I'm going to have is the chap that this lawyer is representing is difficult. So I'm not going to have the difficulty. He's going to have the difficulty trying to discipline this guy because he's S&S, he's stupid stuff, and he doesn't listen. So my feeling is we may have to build a distance because the lawyer's fine to deal with him. Like he understands the reality of what his client did, but his client doesn't get it. So you don't know where you are with these things. But in this particular case, there's no. I mean, this is 100-0. This is not a case where it can be 60-40. And to use your example, it's a crapshoot. Some cases are just so clear. You just shake your head saying, well, what is this? It's just garbage. But there are cases where the liabilities can be split. And where that's the case, if it is a crapshoot, you don't know. And then you've got the expense and the weight and the psychological cost. Not everything's about money. One of the nice things about mediation is it's a very business purposed kind of thing to do. But at the same time, it's heavily psychological. You're trying to appeal to people, we'll use the expression, you're trying to appeal to people's better angels, not their worst angels. And the politicians use that expression every so often. And that's all psychology. Like, how much punishment do you want? Punishment could be money. It could be the fees you're paying for something. It could be the uncertainty of an outcome. You don't know what it is, and you don't know when you're going to get it. You're sitting there eating yourself up alive. There's a psychological cost to conflict. You can drive yourself crazy. And some people are already there to start off with, so it's not going to depend. The world's got a lot of interesting people in it.
Some people thrive on it. It's not
Some
a cost.
Yes, some people are. Yeah, I mean, the guy with the blonde hair I just mentioned thrives on chaos and conflict. His whole life is about that. And nothing purposeful ever gets done. It's just chaos and more chaos.
I think how much money is lost.
Well, and then if you look at, if you live a chaotic life, and then leave him out of it right now, what is it costing you? What are you losing? Opportunity costs? What are you spending on lawyers? Money that you're wasting on a bunch of crap that you don't have to. And what are you doing to yourself in the process? So mediation is purposeful, it's rational, it's directed toward problem solving, but it's also heavily psychological. You have to have all of these sort of attributes to be able to do it. Okay, I want to move on to arbitration in the time that we have because I think they gave us about an hour or so. I get through this one very quickly. What is arbitration? Arbitration is basically a judging exercise, and it's in both sets of material, but I'll just stick with the one I have. It's like a judging exercise, but not in court. So when I wear my judge's hat and I have to put on all my duds and all the rest of it, which look neat, that's great. If I'm arbitrating, I'm going to dress like this. Maybe I'll have a lighter shirt and tie if I don't have a tie that goes with the shirt, but whatever. An arbitrator is basically a private decision maker agreed to by the parties. It doesn't have to just be A and B, it could be multi-party. You can have A, B, C, D, and E as long as they agree on the certain person. Like with mediation, there's a contract that we sign, appoints us as an arbitrator, sets out what our legal duty is to be fair and to be neutral and to be equal and even-handed and unbiased. It's all the same stuff. And take everybody through the process. What arbitration will involve is a certain amount of outreach where the parties will file material. If, in most cases, there's some paper trail. Very seldom will you have something where there's absolutely no paper trail. I had some guys in yesterday who were realtors with a competitor up on Highway 7, and they could be sued on a commission split, A, B, and C. They had an oral partnership agreement to try to sell some property for pre-construction property for a developer. They did it. The commissions were paid to the broker. The broker did a three-way split. Third. One of the partners is now saying, no, I should have gotten 100% of the commission. So there's an internal fight going on. The other two come to see me yesterday. So first question, anybody who's trained in law, did you have a partnership agreement? No, we never wrote anything down. And they're looking a little forlorn. I said, well, you know what happened? Better off if you have something, because there are fewer questions to ask us. It's not the end of the day. I said, you were developing something. You're trying to get deals for a developer. The developer doesn't pop out of heaven. You must know who you are, of course. You must have had meetings with somebody. No. You keep a diary. And I showed them my paper diary, and I have my iPhone diary. I said, you diarize appointments. Yeah. Make copies of your appointments. Go back. You know when this happened. Go back and make paper copies of it. Get yourself a file folder like the one I'm holding up and do something. I said, the people that you marketed for, that you met with them, how did you meet with them? Again, W5, I'm back to the same thing. How did you meet with them? We met at their office. Who was there? All three of us. I said, perfect. I said, you know who they are, they know who you are. What if you just reached out and said, give me a letter saying on a certain date we met to discuss the project, and all three of us were there, and we met with Mr. Jim Smith, the project manager. How hard is that? Oh, okay. Sorry, that's your first homework. I said, who else did you deal with? The bank, because the bank had arranged finance. There was a mortgage officer. I said, okay. Do you know who that is? Yeah. Do you know where that person is? Yeah. And how did you meet them? It's the same questions. How did you meet them? We went to the branch and we met with them. All right, fine. And they know you and you know them and you know what had happened. Get a letter from them, just setting out whatever their recollection is. That's called evidence. So gradually, by the time we finished, I felt like a dentist sort of trying to drill a cavity. By the time I got done, it was an hour meeting. We started at 10:30, it was done by 11:30. They had remembered, just as I was prodding them, 5 outreaches to different people that they needed to converse with in order to be able to do whatever they had to do. Because otherwise there's no sale. The last one was the administrative assistant of the realty company that these two are still with. The other one took off, parts and all. And I said, well, when she split the commission, because you know the vendor developer sends the commission to the broker, and then admin has to split it up. They're going to have to ask somebody what the splits are. They're not going to know. Was there any note or memorandum that any of you guys gave to the lady who makes out the checks? Yeah. I said, why don't you go back to whoever your admin person is at your brokerage, ask her to make a copy. Oh yeah. Right. I had 5 things on their homework list. I called it homework. I feel like a teacher at the time. Right? But I had 5 things on their homework list. Say, that's your homework. There's no advantage to your suing right now because you each got a third. Wait for the hammer to drop. If this greedy guy who wants 100% shows up, you already have all your evidence ready to go. You'll get it to me, and then I'll get retained, and then I know what my defense will be. Okay. So what I'm trying to do is get them to prepare for the fact that they were totally unprepared for the meeting, and they didn't bother writing anything out, but other people can provide it writing. So like, that's part of when you're trained to do all this stuff, whether it's as a judge, as an arbitrator, these are the kinds of questions you're going to be asking. If people come before us and they're not ready, we're going to know where the gaps are. Especially the judge training, I do this all the time. Just say, well, do you have this? Do you have that? Where's this? Where's that? Because you got to know what the story is in order to work out a decision. Right? It's always what are the facts, and then the facts, the law, not back. Hopefully that helps out. So typically at arbitration, what will happen is they'll pick the arbitrator, they'll sign a contract, they'll file a statement, a short statement, just saying what each party's position is. they'll serve documents, whatever paper flow they may have, maybe it's a lot, maybe it's next to nothing, depends on the circumstances. We won't see that in advance, we'll probably see that just when the actual hearing comes up. There's two ways of doing arbitrations, with or without a hearing. The without a hearing can work if it's something where people are not fighting about the facts and it may be a number that they're struggling for. Typical example, commercial leases. Renewal time comes up. Landlord wants $5,000 in basic rent to get the TMI for a certain place for a 5-year renewal, and the tenant winds up saying, I know what's going on in the market, it's not worth more than $4,500. And that's the swing of renewal leases. That kind of dispute can be dealt with without having people going back and forth. If they get us some opinions, or if you want us to blow your brains out, you go to the AACI guys that charge you $3,500 for a simple appraisal report. You get us that stuff, we read it, we'll know what the swing is, because fair market value is a range, it's not one number. What do most arbitrators do? If I were to get 3 reports, one comes in at $4,500 fair market value, $4,750, $5,000. Take one guess where you think I'm going to. You already know the answer. You can the one in the middle, because that one's fair, it's balanced. You're not going nutty on one side, you're not going nutty on the other. It's the old Solomon routine from the Old Testament, right? Cut the kid in half and give one half to each mother. Except that wasn't the point of the story, but we tend to go up the middle. Right? So usually what happens is if it's a simple dispute that's just about numbers, it's not about liability, you don't have all this back and forth, you did this and I did that stuff. We can do it on documents. We don't even have to meet anybody. Just get me your documents, I'll get you the answer. If they need to give evidence, then there'll be a Bible or any kind of holy book and whatnot to swear in the Bible. Who cares anymore? Doesn't really matter, we'll affirm, and we'll conduct it like a trial. So the arbitrators, like a judge, are private. They're not in court. And at the end of it, the arbitrator will look at what's going on, issue something called an award, which are the written reasons for you win, you lose, and will actually, if there are any legal principles involved other than obvious stuff, we'll recite case law, we'll do some research, and make sure there's some cases to support what we've done and why we've done it. We give the award out to each party, and we're done. That's our assignment. It's finished.
Now, because you're acting as an arbitrator, then you can skate up the middle, right? And you can say, I'm going to split the difference.
Right.
But as a judge, if two people are arguing over numbers, say, just to make it really simple, and one guy says, I think the number should be this, and another guy says, I think the number should be that.
Right.
Does a judge have to choose between the two, or can the judge skate up the middle?
So with commercial lease disputes, there's a statute called the Commercial Tenancies Act. Residential is residential, it's the government board, forget about that. But the Commercial Tenancies Act basically empowers judges to make a limited number of decisions where the statute is specific. Like, I don't know, you have a set of commercial premises and you want to sell your business, you want to assign the lease over to the buyer. And the landlord is saying, I'm not going to approve, I don't like that guy. So there has to be reasonable grounds for a landlord to refuse consent to let the lease go across, right? The problem with this other stuff is theoretically a judge could do whatever he wants. He has open authority to do whatever he wants and set the market values. It's not typically what they do. So, and the other problem is it's the kind of case, unlike trying to force a transfer of consent to assign a lease where you can bring a motion and get that done hopefully in a couple of weeks or a couple of months and not make people wait. Regular civil list cases are stuck with this 5 to 7 year thing. What if the lease is a 3-year lease? You're going to be 4 years past that.
I guess what I meant was that what I'm trying to understand is that you warn as I guess maybe I'm more of a mediator now, but you warn the parties that it's a crapshoot. Yeah. You might win, you might lose. Right. So let's create our own agreement. Right. We have control.
Exactly.
That's the whole point.
Absolutely.
So maybe not with a number, but you're at fault. No, you're at fault.
Right.
If that's the argument, right. Does the judge at some point have to say it's this way or that way, or can the judge say, well, you know what, you're both a little bit wrong here?
Yeah, you're right. Exactly. If the situation is not 100-0, if there's sort of each side's done stupid stuff, and the evidence is clear. The same thing for arbitrators. Like the mentality is no different. Right? If you're judging or arbitrating, if each side has something to answer for, whether you're in court judging or whether you're an arbitrator arbitrating, you have every right to say the plaintiff did 1, 2, 3, and the defendant answered by doing 4, 5, 6. The plaintiff, when it did 1, 2, 3, caused a problem. The defendant, the way they answered with 4, 5, 6, also caused a problem. And you basically, you take something off the top on each side. So judges do that regularly. That cases don't have to be 100-0. And cases in arbitration, they're not called cases or claims, don't have to be 100-0. They're very similar in a way. The only difference is, I say, in one case, you got a judge who is a functionary of the court system and we're wearing our robes and all that nice stuff and all that. Looks great. And in the other case, you show up in a suit, but you're really doing the same thing. And there's no Your Honor, right? You don't have titles, just Mr. Arbitrator. But the functions are the same.
Same situation, however, there's a monetary difference, a
Right.
huge difference. That's
Right.
How does that, both stubborn parties,
Yeah.
maybe vendor and purchaser, doesn't matter.
You're talking in arbitration?
And
right?
arbitration,
Well,
yeah.
again, it's a win-lose system. The arbitrator has, there's a tendency in arbitration, and this is interesting because as a small claims court judge, I see it, I see the time. There's a tendency in arbitration to be small e equitable. The judge is often in the high court, the Superior Court of Justice, which starts where small claims leaves and goes right up to the top. Sometimes they're a little bit stricter with stuff like that. In small claims court, which is really an equitable jurisdiction, we overlook a lot of nonsense because we're dealing, 50% of the time we're dealing with the public. No lawyers, no paralegals, they have no clue what they're doing. And we got to figure out the answer. So often, in order to try to make everybody happy, you swing a little bit. You either swing right or you swing left and just sort of get a result that you can live with.
But if the parties.
And arbitrators do that as well. They may not be as strict as a judge in the Superior Court might be, saying this is right, that's wrong, boom, that's the end of it.
If the parties do go to full-blown litigation
Yeah.
in the Superior Court,
Right.
how often is it a you win, you lose situation versus the judge trying to skate up the middle?
Well, the judge will do that. That's the judge's function with the win-lose. In other words, if you do a trial, plaintiff gives its evidence. Plaintiff is cross-examined and his witnesses. And then the defendant gives his evidence, cross-examined. And then the lawyers sum up the case saying, we prove this, we prove that, whatever. At the end of it all, the judge is going to look at all of the evidence, say, here's what I heard, here's what I believe, here's what I didn't believe. These are the facts as I find them. It's the judge's opinion. Here's the law that applies to those facts. Here's the result. Plaintiff wins 75%, and I'm not going to give the plaintiff 100% because the plaintiff screwed up doing number 1, 2, 3. And then they'll set the cost again proportionally to the result. Arbitrators do exactly the same thing.
So let's say within an arbitration, the end result is not satisfactory to one party.
Okay.
What happens in that case?
Okay.
Can they take it to trial back to the
No,
same?
No, they can't. I was hoping somebody would ask because that's a very good question. So the Arbitrations Act has a whole bunch of sections. One of the problems with the act is whoever wrote it should have taken a writing course. I mean, it's just, I did a 40-hour course in arbitration some time ago so that I didn't have to try to pick this up on my own, and I needed a week of sleep to recover. And it wasn't the teacher was great. It was the law. It's just so badly constructed that it's like, when you do the ABCDs, A, B, C, D, E, F, G, H, I, J, K, this was all over. It's like letters that are just flying all over the place. So it's a real nuisance to read if somebody hasn't guided you through it. Long answer short, the Arbitration Act basically does a couple of things. There's a section, which is section 7, that says that where people agree to arbitrate, unless they're stepping on the toes of some specific statute, like the Consumer Protection Act that has its own code, something like that, or the Employment Standards Act that's there to try to protect employees. As long as you're not encroaching on the territory of very specific legislation that's sort of consumer directed, that the courts will respect what the arbitrators do and they'll leave them alone. It's called deference, judicial deference. They basically back out. You want to arbitrate, that's the choice you made. Don't tell me now you want to go to court. If somebody did want to go to court after starting an arbitration, the one side that doesn't like what they're doing could bring a motion to stay the action under section 7, leaving aside the this consumer protection type stuff, it would get knocked down. The other, you may have asked it or not, but the other part to your question would be, let's say, and I think you did ask that, you get through the whole thing and one party doesn't like the result. And they wind up saying, I'm not going to do what the arbitrator ordered. The other party can bring a quick motion. I don't know what quick means, especially in Toronto, because it's just so slow, but a quick motion, so-called, before a judge in motions court, not everything's trials, just saying, we had an arbitration. Here's the arbitrator's award, because we have to do this in writing. So this is not stuff on the back of a Kleenex and whatnot. The arbitrator's award signed off to you, and the other party will not comply. The judge will make a compliance order and make it into a judgment of the Superior Court. So what they do is they rubber stamp this. So if one side sort of gets curmudgeonly at the very end, the court will say, too bad, you went to arbitration, you lost, don't cry on my shoulder.
Unless the arbitrator really made a bad decision,
The only-
and they're challenging the
Yeah.
validity of the
Yeah,
decision.
there are sections 20, 25, and 26 in the Arbitration Act which deal with two levels of challenges. One of them are appeals, which almost never happens, because the appeal would have to, the arbitrator would have to be so screwed up in what he did, where the Court of Appeal looking at it was saying, my God, how did he ever draw those conclusions? And then they set it aside and go to another arbitrator. Almost never happens. The more likely attack is what's called a set-aside application, usually because they'll say there was no agreement to arbitrate, so how did you do it? Or the arbitrator was biased, and he had fits all the way through the arbitration, was yelling, screaming, and swearing at A, and seemed very, very nice to B. He didn't give us a fair shake, he was biased. So remember, a couple of times I mentioned you got to be equal, even-handed, fair, neutral, unbiased, all this stuff. That runs through all of ADR. The mediators are regulated that way. We have to do that. The arbitrators also have to do that. So an arbitrator would really have to mess up in a major way for somebody to attack the arbitration. Short of that, the attitude of the court is you agree to arbitrate, don't cry on my shoulder.
Typically in a court room setting, there's, I guess they record or they keep track of conversation and this and that. Is
Court-
there such thing in arbitration?
Yeah, there is another very good question. In courts, there's always a transcript. Any judge who sits in court, in my court, the small claims court, we have a single registrar who acts both as a clerk and as a recording person with a recording device that's probably, I don't know, maybe 15 or 16 inches long, but maybe a foot wide, with tapes and all kinds of stuff. It's their job to do that. In the Superior Court of Justice, they have more staff where they have the recording person who's the registrar. They'll also have a clerk who hands files back to the judge, or hand me this, hand me that. And they may have a third person who's a bit of a security officer dressed a little differently. So there's more infrastructure in the Superior Court. The simple answer is that it's all recorded. In an arbitration, especially if it's really complicated and there's legal issues, and there's the risk somebody might try to do something in court. In an arbitration, the arbitrator will arrange for a certified recording person. Usually, because people don't want to run around with equipment, because equipment's big and it's heavy, is you would do an arbitration at an office where lawyers typically will do their discoveries. If you're a lawyer and you're in litigation, there are a whole bunch of what are called certified court reporters. They have their own offices. The one that I use is Young and Shepherd. It's a huge place. It's a whole floor. And it's broken into large rooms, not as big as this, but large rooms that maybe you can get two into one of this size. And then little breakout rooms if you need to have a conversation with somebody. And you pay by time and you pay by the word. So there's a time charge. If you order the transcript, it's so much a page. Now, depending on how much talking goes on, if you have a transcript that's no thicker than my little file folder, that's a cheap day. If you have somebody who goes on and on and on, you have 4 days of evidence. You could probably run a bill for $1,500 just in transcripts. Somebody has to sit and key all this out. So the simple answer is, yeah, it's got to be transcribed. For mediation, no. We'll take notes, but nobody sees them. It's just notes for ourselves, and it goes into a file folder and away. Arbitration, you pretty well have to do transcriptions. And
Do
of course,
you
it's automatic.
keep your mediation notes?
Yeah, I do.
Don't some people destroy them?
You can. One of the things in mediation is that because mediation is a without prejudice settlement offer type deal, that no mediator, and that's right in our agreements, can be compelled on a subpoena to testify in court about what went on in the mediation. They can't do that. We're protected that way. And it's right in our agreement. We have a clause in there saying that, you know, if you get into a fight later on, don't yank me into this kind of stuff. We do our best to do what we have to do.
What if one party is not satisfied with the mediation?
Mhm.
What would be the next step?
Well, I guess the question before that is, did they resolve the issue? If they did resolve the issue, and if they signed the memorandum, and the third if is, if there are no conditions on it, I think when you're doing deals, conditional on something. So as long as it's not conditional on something, then the other side could bring a motion for judgment in accordance with that settlement. Right? Again, it's a court motion. Just say, we settled all this, there are no conditions, we're done. And the other side, you know, had a change of heart afterward. And they move for judgment. The judge will enforce it.
Sorry.
Yeah, that's okay. So that's the long and short of that. So a completed unconditional mediation agreement can become the subject of a court order. And an arbitration award if one side says, oh, I don't like what the arbitrator did, to make also the subject of a court order. There's sort of a similarity in the way the courts deal with this kind of thing. They're not connected because mediation is an agreement process. And arbitration is a judging process. You're right, you're wrong, you wouldn't be. But there's a lot of common factors that are common to both.
So
You look at them, you can see it's the same stuff on either side.
So within a meeting with someone who comes to you, do you suggest which way you should go, arbitration or
I usually will. Like, for example, I've got something, the firm that I'm subletting from or some other lawyers, and, you know, they know that I'm doing it. And they said, we have somebody, we don't know if it's going to work or not. It's a family where there's some aunts and uncles and cousins who have ownership interests in a piece of real estate. And they know that I did 42 years of a lot of real estate. And they told me a little bit about it. I don't want to hear too much because if it comes to me, I don't want to have an impression. But they told me a little bit, enough that I said, this sounds like a situation. The family get along well. They love each other. They're not enemies. Nobody's looking to mess anybody around. Nobody's looking to go to court. I said, so forget about court. It's just hopeless. But as between mediation and arbitration, they should mediate. And I was told just a little bit, enough that I got sort of a taste of what the case is about. I said, this property is a half-day mediation. I know exactly what I would do with it. From the little bit I was told, I'd already figured out what the plan would be to get these guys to just get finished. The risk they're facing is because somebody got stubborn, whoever was the person making mortgage payments, stopped making mortgage payments. A notice of sale has been issued by the bank that holds the mortgage. I mean, that's just silliness. So if that came before me, I'd say, look, you got to get this mortgage back, you know, in good condition. Your stubbornness can cost you the property. If you think you got aggravation now, wait. I'd be very blunt with them, saying it's just not the way to go. So you have to counsel a little bit too. I mean, as soon as I said that, I noticed grimaces. There's, oh God, what are they doing? Well, because it's dumb. But sometimes people, when they're angry, they make dumb decisions. They need somebody else to say, back up. What are you doing? What will happen if you continue to do what you're doing? It doesn't make any sense. Well, mediator can do that. We can't be there and we have to be active, but we have to be honest at the same time, saying, look, this is a prescription for disaster. Let's see if we can put this in. That's part of the mediator's job. It's creative. But being creative doesn't mean that you're sitting there and listening to a bunch of BS. It's not going to persuade anybody of anything. You still have to be blunt with people, saying, that's not the way to go. This is what you need to do. So arbitration in a nutshell is something that you would use, a conceptual look at it, is if people just can't negotiate, they're trying to, but maybe there's an issue, and it sometimes happens. Could be an issue of legal principle, where people say it's not just a matter of you take 5 and I take 10 and you throw numbers around. There could be something in the nature of their conflict where they need to have somebody make a statement as to what the principle is that governs their behavior. It doesn't have to be law. It could be engineering. It could be construction. It could be biology. It could be chemistry. It could be property rights, patent, trademarks, and copyrights. There's all kinds of technical areas where people say, I need to know what my legal position is in relation to the conflict. It's not just a business of I spend $6 or I save 10. It's not just that. So sometimes you do have to arbitrate or go to court, one or the other, to get a resolution of that kind of issue. Most of the time, if the law is, or principle is not the issue, it's not a question of principle, it's a question of money, usually it's a question of money, then you can probably mediate it rather than arbitrate. Why is it better? You got it right. You have control. When you mediate, you have control over the outcome because you're agreeing to it. If you agree to something, you're taking ownership of the product. If you arbitrate, you're giving ownership to the arbitrator, win or lose. So the word that you use is control. It's exactly the right one. Okay, I think we're okay. I'm okay to stay, but I know it was booked for about an hour, and I don't want to hold people up. So
I'd like to discuss something with you.
yeah, sure. Does
I'm not
anybody?
gonna do that all
You've been the
this
two
stuff.
active ones. Anybody else have any other questions before we wrap it up?
I'll be back. I'll come.
Okay, no problem.
Just one quick one.
Yeah.
Maybe you said it and I didn't hear it.
Yeah, no problem.
But,
I'm just gonna go to
But there is
Okay.
an arbitration, and the guy says, this is what I decided.
Yeah.
Is that final, is that something?
Yeah, it is. And I mentioned that this lady was asking, what happens if one side says, oh, I don't like that, I don't agree with the arbitrator. The other side can bring what's called a quick motion to the court, the motions court, saying, Judge, rubber stamp the arbitrator's decision. We agreed to arbitrate. Here's the arbitration agreement. Here's the award that the arbitrator gave. Rubber stamp it. And it becomes a judgment of the court. Okay. I think that was this lady.
Yeah, I couldn't.
Yeah, no problem. Yeah, what they're trying to do is they're trying not to look over our shoulders. They're giving us authority as long as we don't do things that are crazy or stupid to stick to it.
And you do both, right, mediation? and
Yeah.
arbitration?
Oh, yeah. I'm trained in all this.
What's
I
your-
can help people negotiate too. Because sometimes I'll get people who want to start crazy lawsuits and I'll talk them out of it. I probably, when I was practicing law strictly, doing that, gave up tens and tens of thousands of dollars of retainer money on what to me were stupid lawsuits. And I'd say to the client, do you really want to do this? Like, do you have any idea what kind of hole you're digging for yourself? Even if you're right. And often they weren't right, or it was one of these mixed situations where it could be 50-50. You don't know what a judge is going to do. Your colleague's word was crapshoot. Do you really want to do this? Is it worth it? Sometimes, you take a small loss and you just move on.
Yeah, exactly, moving on, like
Thank
you
you.
said, it's gonna
Thank
take
Okay.
7 years.
Yeah.
If you wanna go to court.
Well, that's the other part. It's sitting.
It's always on your mind.
Yeah, it's sitting, messing with your brain for 5 to 7 years. Okay. All right. Thank you.
I'm gonna recommend you
Yeah.
to speak to someone. It's a client of mine on the
Yeah.
purchasing side. And he's just being very stubborn.
Yeah.
And he's getting himself into so much trouble.
Remember I said the 2 S's are stupid.
Yeah, and he's being both. So unfortunately,
You mean what?
he's being both stupid and stubborn.
Oh, I see it all the time.
The lawsuit, myself and Jack, who's our manager,
Yeah.
Jack Fusco, he's spoken to him and given all kinds of information, but he's just not cooperating.
Right.
So what I'm gonna do is I'll pass your number along.
Yeah, please.
I don't have my business card with me, so I
Okay.
can pass it, but I've done business. with
Yeah,
you
yeah. No, I know
in the
you
past.
did.
Even my
Unfortunately,
personal stuff.
that light is
actually.
so bright I couldn't see it.
Oh,
until
that's
you
okay,
came
don't
up.
worry
It's
about
sort
it.
of
I'm
hiding
glad
the
you're
light.
doing this though. I think
Yeah.
a lot of people would benefit from your help,
Yeah.
for sure.
But one of the things I did, and just the we're off camera now. I say, are we done? Or?
Yeah,
No, it's
absolutely.
actually on.
Oh, it's
because I
on,
think
yeah.
it's that's
Oh,
talking.
is there still a camera?
I don't know how you. Like, I don't know where
let me
this
tell
stuff is,
Celeste,
and I couldn't figure out what to do.
You know what, I'm gonna go downstairs and
Yeah,
call
we should-
Celeste.
Yeah, yeah, maybe we should just
Give me 1 second.
tell them to kill it, and then we'll talk.
I have taken the ADR course at York, and
I had a feeling because you and this lady were the ones questioning, to the exclusion of anyone else. I figured I bet she's done some reading because your questions sounded informed. It's not like you're coming in and hearing this stuff for the first time.
yeah,
People are quieter.
Sorry if I didn't ask, because honestly, to be honest,
Yeah.
this is the first time that I'm hearing about
Oh, yeah.
those words.
It's
I
new.
never, absolutely, it's
Yeah.
new. That's why, because
Yeah.
since I started, you know just the lawyers, and
Yeah.
that's it.
Well, because you're trained in real estate, so your function is that function.
Yeah.
The point of
and
doing,
we've been trained.
yeah, he had some
though-
other training, so that's why he was one of the questions.
Even though I had some situation for some different clients, about the court and judge and lawyers, but
Right.
I never heard about those words
No, I
and
know.
you try and use.
You know what, I've been reaching out, because I retired as a lawyer after 42 years. And I could have sort of stayed home and did nothing, and it's not me, I'm gonna be active. So I made arrangements to sublet a smaller office, just big enough, I could use some more space. The rent's so cheap, it's a joke, right? So I'm not at risk that way. And I've been reaching out by phone and by email to brokers now, virtually from the time that I packed in my practice, which was the end of December. So letters like crazy, and sometimes it's amazing. I've gotten a good response, and I don't have a marketing background. I've had to figure this out, as I mentioned before, because I am not trained in marketing. And lawyers have different backgrounds. We sort of create business a different way. But one of the things that I discovered going through this was that my success rate, because this is unsolicited, some of the people I'm writing to know who I am. I'm getting calls returned faster.
Sure.
Some of a lot of them, one of the things I didn't know either is a lot of the brokers are not around very much. And they have managers.
Yeah.
So I discovered after a couple of weeks, because I'm wandering as well. Discovered after a couple of weeks, it's a manager who's the one who sets these deals up. I knew who Vivian Reese was. I knew who Michelle was, because there's family stuff in the background there. Marty is my daughter-in-law. Marty.
Oh,
Neil's my son. Marty, yeah.
She's
So like I knew the connection, and I knew about the academy and stuff like that. But I didn't use that to get in. I just wanted to do stuff on your own merits, right? But I knew that you had a really fancy operation here. I said, I'm going to reach out to the Reese's. Well, they knew the name because they were at my son and Marty's wedding.
Of course, yeah.
All right. So they responded right away. If I got the call number 4, knowing that the person I'm trying to reach is around, they're not on holiday, it isn't Easter or anything like that, they're not in Florida, and I don't get a call back, I move on. Because I figure if
You don't
they were
wanna bother
interested,
them.
they don't want to bother, but they're not going to call back and say, look, thanks
Leave me
very
alone.
much, we're not interested, leave me alone. So, but I'm patient. I'll give it 4 rings, nothing back, goodbye. I just move on. I'll Google, the names and addresses and phone numbers. If I get a response back within 4 phone calls, and it's usually a manager, and I didn't know that. I assumed it was the brokers, but it's not. It's usually the managers doing all the work. Then I'll say, look, if you're interested and you see that this would benefit your agents and whatnot, I don't know how many, whatever it is. I'll email you some material. I got a ton of material on my website, which if you look at the card, you'll see it's ZwickerDisputResolutions.com. I've done a lot of reading. There's tons of stuff, magazines and non-written. And there's almost nothing I haven't written on that isn't published on that website. So then I said, let me send you the piece that I would use as a text, which is what these pieces were about.
Yeah.
Inevitably, if they look at it, I get a yes. So the trick is converting phone calls that often get ignored to a yes. I probably, by the time I get done, I
They're
will
off
probably
recording.
be.
There's no recording. Can I grab a few more business cards?
Yeah,
please?
sure, take it.
Just-
They don't charge very much.
just- Thank you.
I got it.
Take care.
So-
Thank you so much.
Yeah, not a problem. Yeah, I forgot what I was saying. Oh yeah, the conversion rate. I'm hoping to have done by the time I get finished with this about 20. I probably either done or have commitments to do about 13 or 14 at this point. I'm hoping to pick up maybe 6 more. That's on a list of 80 possibles. I didn't reach out to all of the 80 possible. We're up now, I guess.
Thanks, sir.
Okay, I hope you enjoyed it.
Thank you so much.
Okay.
I appreciate it.
I didn't reach out to everybody. Summer's so bloody far away. I don't want to. I'm getting older, too. I'm going to be 70. I don't need to run all that much. So that was great.
It was great.
I hope so.
We're getting such great feedback
Yeah,
online as well.
Voice was clear and all the rest of it.
Yes.
Yeah. I did some TV years ago, but I was very lucky. That writing style was journalistic style. If somebody were to look at my website, go to publications, they'll see the last number at the very top, which are most recent, are mag publications. 5 of them are with Canadian Lawyer, which is our national magazine. I'm not shy. I called the editor. I said, you don't know who I am. The editor's name is Tim Weber.
You pitched a story.
I pitched the story. I said, look, I'm a lawyer. I'm retiring. I'm trying to move the needle. It's almost like moving the clock from 12 o'clock to
Just gonna
12:05.
remove the line.
And I have a piece on arbitration.